The country is following a mounting clash between the Trump administration's effort to declare wartime powers to deport when there is no war. Now, that was ruled unlawful by a federal judge. Then there were reports that Trump officials deliberately defied that judge's order. President Trump then unloading on that same judge, demanding his ousting through impeachment. All of this coming through in the past 24 hours on this story that we've been bringing you. Now, the court process part will take time. But as this clash escalated, legal experts wondered if and how the Supreme Court would view these blatant efforts to test or defy court orders, and would they weigh in some manner or more quickly? Because Trump is accused here of not only obviously violating the law full stop, saying I have wartime powers when there's no war, but then furthermore, allegations and evidence that he would abuse power and try to intimidate that judge.
Let me annotate 4 specific documented elements from that clip with the precision they deserve. First, the wartime powers episode. The administration invoked wartime deportation authority in the absence of a declared war. A federal judge ruled this unlawful. Reports emerged that administration officials deliberately defied the order. Trump then called for the judge's impeachment. I want to place this in the precise constitutional framework I developed in episode 12. In the Youngstown steel and tube analysis, the foundational framework for executive authority claims, the Supreme Court established that when a president acts in ways that Congress has not authorized and may have prohibited, executive authority is at its lowest ebb. Wartime deportation powers exist in specific statutory form under the Alien Enemies Act of 1798, which requires an actual state of war or declared invasion. Invoking those powers in the absence of a formally declared war for the purpose of bypassing the normal immigration enforcement framework is precisely the kind of executive authority claim that courts applying the Youngstown framework and the major questions doctrine I analyzed in episode 12 are designed to constrain. The documented sequence, ruling, defiance, judicial impeachment demand, is the most direct documented instance in the series of the administration asserting the right to operate outside judicial constraints in real time, not as a theoretical position, not as campaign rhetoric, as documented conduct. Second, the 17 injunction figure. District courts have blocked at least 17 major Trump policies through nationwide injunctions. The source characterizes this as extraordinary. I want to give it the precise historical context that makes that characterization analytically supportable rather than merely dramatic. The nationwide injunction, a court order that blocks a policy not merely as applied to the plaintiffs in a specific case but across the entire country, has itself been a contested legal tool, criticized by legal scholars across the political spectrum as potentially exceeding the remedial authority of district courts. The fact that 17 major Trump policies have been subject to such injunctions is significant not merely because of the number, but because of what the pattern documents. Courts across multiple jurisdictions, appointed by presidents of both parties, applying different legal standards to different policy areas, have consistently found that the executive branch exceeded its constitutional or statutory authority. That convergence is the documented institutional signal I have been tracking across 13 episodes. The 17 injunctions are not coordinated, they are independent. Their consistency of outcome is the documented evidence of what the administration's exercise of executive authority has produced when subjected to judicial review. Third, Judge Hellerstein's ruling. Hellerstein's documented holding that Trump's latest attempt to relitigate the hush money conviction constituted 2 bites at the apple is a precise legal characterization of a documented procedural pattern. The systematic filing of successive motions, raising substantially identical arguments in hope of a different result. The 2 bites doctrine is a real procedural principle. Once a legal argument has been fully litigated and decided, with the opportunity to appeal, the losing party cannot relitigate the same argument in a new motion asking for the same relief. The doctrine exists because the finality of judicial decisions is foundational to the legal system's function. If every judgment could be reopened indefinitely by successive motions, no judgment would ever be final. The documented fact that Hellerstein applied this doctrine to Trump's motion is a procedural finding that the conviction has been fully and finally litigated through every available challenge. The conviction stands. This is not a political characterization. It is the documented judicial status of the case. Fourth, the impeachment demand against the judge. I documented in episode 5 that the administration began publicly calling for judicial impeachment beginning March 15th, 2026. The wartime powers episode adds a specific documented instance of this pattern. A ruling that the administration found unfavorable produced an immediate presidential call for the judge's removal from office. This
is one of the most significant cases that the justices have decided in recent years. Here, the Supreme Court ruling that President Trump's use of these emergency tariffs that he has implemented are illegal. It's the most significant economic case to reach the high court in years, sweeping implications for the economy and, of course, for presidential power. And at stake here are billions of dollars in revenue that have already been collected by the government. Pamela Wolf, the other significance here is that this is the first time that the 6-3 conservative court has ruled against President Trump in one of these major cases that have gone before the court since he returned to power in January. Now, we are still going through this case, but this is something we have been waiting for. The court said that it would take up this case on an expedited basis. So they're deciding, even though it's a significant case now, because of course this has enormous implications. So as we go through this opinion now with our team, another outstanding.
The source's three-part framework is accurate in its identification of the relevant variables, the legal foundation, the political momentum, the midterm factor, but each deserves more precise analytical treatment than the source provides. And the closing observation, not certain but inevitable, is the phrase I want to address most precisely. Let me give you the honest analytical version of each of the three parts, and then the honest analytical version of the inevitable question. The legal foundation analysis is correct. Systematic defiance of court orders and attacks on the judiciary's constitutional authority are categorically different from policy disagreements and are specifically the type of conduct the impeachment mechanism was designed to address. Article 2's high crimes and misdemeanors standard has been understood since the founding to encompass conduct that fundamentally undermines the constitutional order. I will develop this more fully in Block 5. The political momentum analysis requires the precision I have applied across 13 episodes. The documented pressure is real, the approval trajectory is real, the compound effect is real. But momentum is not a constitutional mechanism. It is an electoral and political variable that affects the third Nixon factor, partisan protection calculation, without by itself producing the congressional mathematics the removal mechanisms require. The midterm factor is the most important of the three, and the one the source correctly identifies as the structural decision point. November 2026 is where the congressional track either reaches the threshold it requires or it does not. The numbers the source gives, then if Democrats reach 52 Senate seats, 15 to 17 Republican crossovers are needed, are correct. The analysis of what compels Republican crossovers, being forced to choose between Trump and the Constitution, is correct at a general level. The precision it lacks is the specific documented mechanism by which that choice becomes forced rather than merely desirable. That is what Block 5 is about. The honest, inevitable assessment. Let me state precisely why I refuse to use the word inevitable, while simultaneously acknowledging the documented seriousness of the trajectory I have been tracking. Inevitable means that the outcome will occur regardless of the specific choices made by specific institutional actors between now and when it occurs. It means the process has reached a point where no individual decision can alter the direction. The American constitutional system does not work that way. Every outcome in this system, including Nixon's resignation, required specific documented decisions by specific individuals. Nixon could have chosen to fight on and refuse to release the tapes. The Republican senators could have calculated differently and maintained partisan protection. The House could have failed to reach the votes for impeachment articles. None of that happened. The outcomes were produced by specific documented decisions at specific moments under specific pressures. What I can say, with full analytical support from the 13-episode documented record, is this. The institutional conditions that would make accountability outcomes possible, that would make each of the 3 Nixon factors reachable, are more fully developed right now than at any previous point I have documented. That is a different and more precise claim than inevitable. It is a claim about documented trajectory, documented conditions, and documented threshold proximity. The difference matters because it is honest. And 13 episodes of documentation that I claim to be honest require an honest conclusion. The 4-track synthesis, where each variable stands, track 1, the judicial track. I have now documented, across 13 episodes, a pattern of judicial constraint that is without precedent in scale, consistency, and institutional breadth in modern American history. The civil fraud judgment, $354 million fraud finding upheld unanimously, penalty under recalculation. The D.C. Circuit immunity ruling, unanimous, no presidential immunity for criminal conduct. The IEPA tariff ruling, 6-3, major questions doctrine, constitutional theory invalidated. 17 nationwide injunctions blocking major policies across immigration, war powers, environmental regulation, and trade. The hush money conviction standing, 2 bites doctrine applied, no relief. The wartime deportation authority claim found to lack statutory predicate. Every one of these is a documented judicial finding entered into the permanent legal record, produced by courts across multiple jurisdictions, appointed by presidents of multiple parties, applying multiple legal frameworks, arriving at the same documented type of conclusion. This administration's exercises of executive authority have exceeded constitutional limits. The judicial track has advanced the first Nixon factor, Supreme Court elimination of legal protection, more substantially than at any previous point in this series. The IEPA ruling is the most direct and most consequential documented constraint. The wartime powers episode, if it develops into sustained documented defiance, approaches the direct confrontation scenario I analyzed in episode 9 more closely than any previous event. Track 2. The legislative track. The documented congressional record, House Resolution 353 with 7 articles of impeachment. The Epstein Files Transparency Act at 427-1. The War Powers Senate vote with 5 Republican crossovers, the Mace letter as permanent Republican source documentation, the bipartisan Bondi contempt enforcement commitment, the 140 House impeachment votes from December 2025 as a documented floor. The legislative track has not advanced the second Nixon factor, congressional mathematics becoming untenable, to the threshold the Nixon framework requires. The House majority remains Republican. The documented Republican Senate crossover count for impeachment conviction remains far below 20. The partisan protection has not collapsed. What has developed? A documented architecture of impeachment readiness, articles drafted, bipartisan signals documented, Republican defection instances documented, that would be activated more quickly by a House Democratic majority than any previous impeachment preparation. The November 2026 decision point for this track is real and analytically critical. Track 3, the retribution apparatus track. Across episodes 2, 5, 6, 9, 11, and now 13, I have documented a systematic pattern. The administration using multiple institutional mechanisms, the DOJ through Halligan, the FHFA through Polt, judicial impeachment calls, the Bondi DOJ deployment, against the network of institutional actors most responsible for the accountability record I have been building. The retribution apparatus track does not by itself move the Nixon factors, but it has produced documented institutional counter-responses that do. The Mace letter, Bondi subpoena proceedings producing Republican defection, the Halligan prosecutions being thrown out, constitutionally defective appointment failing twice, the Boasberg ethics clearance, retribution attempt producing institutional vindication of the targeted actor. Each counter-response is a documented institutional signal that the accountability mechanisms are functioning despite the retribution pressure, that the targeting is not producing the deterrence effect it appears designed to produce. Track 4, the economic electoral track. The Iran operation timeline collapse with the president's own documented acknowledgement of electoral damage. The IEPA ruling removing the primary unilateral trade mechanism from the second-term strategy. the documented 42% approval rating, the 23-point demographic swing, the stock market volatility the source references, the compound economic pressure building toward November 2026. The economic electoral track is the most direct input into the partisan protection calculation for Republican incumbents in competitive districts. The November 2026 electoral environment is being shaped by every element of this track. The Iran operation's economic consequences, the trade policy instability produced by the IEEPA ruling, the economic uncertainty generated by the full pattern of governance disruption I have documented, the Republican calculation, what forces the choice. The source argues that Republicans are being forced to choose between Trump and the Constitution. I want to be more precise about the mechanism through which that choice becomes forced, rather than merely theoretically available. Republican incumbents in competitive districts face a specific documented electoral calculation, the voters who determined their margins in previous elections, moderate Republicans, independent voters, suburban voters who care about institutional stability, are the voters most likely to respond negatively to documented associations with conduct the courts have formally characterized as unconstitutional. The 17 blocked policies, the wartime powers episode, the calling judges criminals, the documented defiance, these are not abstract. They are documented events that are available as campaign material, verifiable from primary sources, and consistent with a narrative about constitutional governance that moderate voters respond to independently of partisan affiliation. The documented Republican defection instances I have traced across the series, 5 senators on war powers, the Mace letter, the Boasberg defense by ethics clearance, are each a documented instance of a Republican calculating that alignment with specific conduct is more costly than the political risk of distance from it. Each instance is a data point in whether that calculation is trending toward a threshold. The November 2026 elections are the structural mechanism through which that calculation becomes binding. A Republican incumbent who voted to protect the administration from accountability for documented judicial defiance faces that vote as a campaign record. A Democratic challenger who runs on constitutional governance faces an opponent with a documented record of constitutional violations that courts have formally entered into the permanent record. That is the mechanism. It is not inevitable that it produces the needed outcome. It is documented that the conditions for it to produce that outcome are more fully developed than they have been at any previous point in this series. The complete 13-episode documented record. A synthesis. Let me state what the complete 13-episode documented record shows as precisely as I can. A sitting president of the United States holds 34 documented felony convictions, the first in American history, with an unconditional discharge that preserves the conviction in the permanent record. A $354 million civil fraud judgment found his financial statements fraudulent across a decade of transactions, with the fraud finding upheld unanimously at the appellate level and the penalty under recalculation. The D.C. Circuit unanimously documented that no presidential immunity covers criminal conduct. 6 Supreme Court justices, including 2 of his own appointees, formally documented that his constitutional theory of emergency economic authority is constitutionally incorrect. 17 nationwide injunctions have blocked major policies. A court-appointed monitor watched the Trump Organization's financial transactions. The attorney general he fired faces a personal congressional subpoena for Epstein file handling, with a Republican colleague formally documenting that she handled them terribly and undermined the president. He signed 2 primary residence mortgages 7 weeks apart in 1993 on properties used as rentals, meeting the standard his own FHFA director stated as the trigger for criminal referral, a standard applied to 4 Democratic opponents. The Wartime Deportation Authority claim was found to lack statutory predicate and reported to have been defied. He publicly called federal judges criminals on March 25, 2026, demanded legislation to punish them for rulings against him, and called for judicial impeachments. The Iran operation entered Week 7 having missed its stated timeline twice, with his own documented acknowledgement that economic consequences may extend through November 2026 elections. The AEPA ruling invalidated the constitutional theory underlying the second-term governing strategy's primary bypass mechanism. A Republican congresswoman produced an official congressional letter documenting specific conduct failures by a Trump appointee. Every one of those documented facts is in the permanent institutional record. None of it requires editorial framing to convey its seriousness. None of it is speculation or fiction. It is what the documented record shows. Now here is the honest analytical conclusion. The documented record describes an administration under the most concentrated, sustained, multi-institutional accountability pressure in modern American history. The trajectory, across all 4 documented tracks, points toward continued and potentially accelerating pressure through the November 2026 decision point. The conditions for the 3 Nixon factors to converge have advanced further than at any previous point in this series, but have not reached the specific threshold the Nixon framework requires. November 2026 is the structural inflection. If Democrats win House control, the congressional mathematics change and the second Nixon factor becomes achievable. If the judicial track continues developing, particularly if open sustained defiance of a specific court order occurs and triggers the direct confrontation scenario I analyzed in episode 9, the first Nixon factor advances further. If Republican incumbents calculate, district by district, that the documented record makes continued partisan protection more costly than selective distance, the third Nixon factor begins to develop. None of that is inevitable. All of it is documented as the trajectory of real institutional forces operating in real time. 13 episodes, 46,000 words of documented institutional analysis, a complete record of 4 parallel accountability tracks, developed across 12 months of documented events, converging toward a structural decision point. Let me state what the complete documented record establishes. The judicial track. The most comprehensive accumulation of documented judicial constraints on a sitting president's exercise of executive authority in modern American history. 17 blocked policies, unanimous appellate findings, the IIEPA ruling invalidating a constitutional theory, the conviction standing, the wartime powers claim rejected, the Boasberg ethics clearance documenting that judicial preparation for presidential noncompliance is institutionally appropriate. Every element of this track is in the permanent legal record. The legislative track, House Resolution 353 with 7 documented articles of impeachment. The Epstein Files Transparency Act at 427-1. The bipartisan congressional subpoena architecture, the Mace letter, the 140 documented House impeachment votes as a floor, the November 2026 election as the structural mechanism that determines whether the floor becomes a ceiling or a majority, the retribution apparatus track, a documented systematic pattern of using multiple institutional mechanisms, DOJ, FHFA, judicial impeachment calls, constitutionally defective appointments, against the network of institutional actors most responsible for the accountability record, each retribution effort documented, each producing institutional counter-responses that entered the permanent record alongside the retribution itself, the economic electoral track, Operation Epic Fury in Week 7, with a documented timeline collapse and the president's own acknowledgement of electoral consequences. The IEEPA ruling removing the primary unilateral trade mechanism, the 42% approval rating, the demographic swing, the compound economic pressure building toward November 2026, 4 tracks, 13 episodes, the most complete documented analysis of presidential accountability pressure this series can produce. I said at the opening of this episode that I would not use the word inevitable. I will keep that commitment at the close. What I will say is this. The documented record across 13 episodes describes with precision a presidency whose relationship to constitutional authority has been formally documented as constitutionally insufficient by the highest court in the land, by unanimous appellate findings, by 17 district court injunctions, by a Republican congresswoman's official letter, and by the documented 1993 public records that his own administration's stated standard would classify as criminal. That documentation is permanent, it is precise, it does not expire. The the accountability mechanisms, courts, Congress, elections, independent journalism, regulatory oversight bodies are functioning. They are slower than the dramatic framing implies. They are more uncertain than the inevitable language suggests. And they are more real, more documented, and more institutionally durable than any fictional scenario. After 13 episodes, the honest analytical assessment is the documented trajectory points toward the threshold. Whether it reaches the threshold depends on institutional choices that have not yet been made. The November 2026 elections, the Supreme Court's future rulings, the Republican leadership's evolving calculations, the administration's own choices about whether to sustain or escalate the documented pattern of judicial defiance. The documented record is there. All of it, in primary sources that are public, verifiable, and permanent. This is Matthew John Turner. It has been 13 episodes. The series concludes here, but the documented record does not conclude. It continues to develop in real time through the institutional mechanisms I have been tracking. The primary sources I have cited across this series are all public. The Engerin judgment, the D.C. Circuit ruling, the IEPA ruling, the Mace letter, the Epstein Files Transparency Act, the ProPublica mortgage records, the Boasberg ethics clearance, the McConney trial testimony, the Bartiromo interview, the March 25th rogue judges statement, House Resolution 353. Read them. Everyone is available. Everyone is more powerful than any commentary, including mine, that describes them. The documented record is the accountability story. It always has been. I will see you when the next chapter begins.